do. We are finishing up the judicial branch. So I'm wearing my party outfit, as you can see, because I'm super excited that we're finally going to finish something. So just want to let y'all know, last one, judicial branch. So what's going to happen is after we do this, I'm going to post on AP Classroom the progress check. Remember, we had 2 progress checks for Unit 2. Unit 2 was institutions, which means that's the legislative branch, the judicial branch, the executive branch, and the bureaucracy. Okay, you guys did the first one. That was going to be in January and February. That was your legislative and your executive, and you guys did that progress check on AP Classroom. Well, today, after I'm done and I've uploaded everything, you guys have been able to watch everything. You've taken notes, right? What I'm going to do is I'm going to post the AP Classroom progress check for the other half, which is going to be bureaucracy and the judicial branch. Okay, so if you need to, go back through the judicial branch, peek at bureaucracy. Remember, anything that you did not do the third 9 weeks, you can still do if it is on Google Classroom. So if y'all need to fix grades or anything, that's the spot to do it. So anyway, we're going to finish this up. The last thing we're going to talk about is something called activism and restraint. I'll talk about what each one of those means. We're going to talk about a few of the justices that work with activism and that work with restraint. Hopefully I will have a video that works. We'll see. I know I have technical difficulties sometimes, but you know, this is all new to me. So anyway, let me go ahead and put me away in the corner where I belong. There I am, in the corner. Okay, so we're making sure you know where we are. We're down here, institutions, judiciary. Now remember, I said this is Unit 2. This is Unit 2 for College Board, but remember, I switched around some stuff to make sure we went over certain things concerning politics at a different time. So I have their Unit 2 is my Unit 3. And I know that's kind of confusing, but on my website, it says Unit 3. On College Board, this is Unit 2 institutions. So y'all should know that. Cut. So down here again, Unit 3.4, institutions, judiciary. That's where I'm going to be putting this stuff. It's also going to be on Google Classroom. So y'all have 2 places you can find it. Hopefully the next time we get to talk, it will be live. The district got rid of us using live Zoom, which is why the day that we were going to start it, I said we couldn't, and then I took it away because the district said we were no longer allowed to do that. And if you look up some of the stuff going on with Zoom right now, they are running into people getting into teachers doing a live, and they act and do really bad, ugly, sometimes gross things, and that in turn is putting kids under 18 in a place where they shouldn't be. So we get to use something called Microsoft Teams. I played with it today with Ms. Heyer to see how it would work. It's a little bit different, but it'll work. I will probably have one just to say hi to you guys, maybe tomorrow. It only shows, it's like, it would be like this screen, but it would only show 4 people, and it's the 4 people that had the most recent things to say. So there can be 100 people in one of these, but you only see 4 people's faces. And they can change though as people, you know, talk and stuff like that. So it's a little bit different than Zoom. Zoom, I would be able to see every single person that had a video feed. In this case, I wouldn't be able to do that. It also has chat capabilities and things like that. So we're gonna work through it. I'm gonna do probably the first one tomorrow. I'll let you guys know. I haven't figured out how to do join codes or anything like that. We're waiting for the district to give us the thumbs up, go ahead and do one. So that's why I haven't done anything with it yet. I'm trying to be a rule follower. Okay, so make sure Khan Academy still there, 50 points. Remember, that was assigned to you guys before we even went into our weird quarantining situation and social distancing situation. So do it, it is points. The grade book right now is not being touched. However, all teachers are still keeping paper grades, what we used to do a long, long time ago when we had grade books that were, you know, little green things that we'd carry around with us. So here's where we are. If you scroll down, we're day 5, last day of the judicial branch, which if you've noticed, we've kind of done every other day. So I've kind of been on like an A-day, B-day type schedule where I created something for every other day. This will be day 5, and we're only actually 1 day behind what I wanted to be. So we're actually still on schedule for the most part. So if you look, we have day 4 right here. That's what we're going to be talking about today. I know it says day 5, but I had the day where we did just Federalist 78. And yes, that video is up. It's on my website and it is on Google Classroom for you guys. So technically it's day 4, new information. We have the crash course right here on judicial decision making. So basically the process that judges have to go through. And we have the battles that they have within the Supreme Court. We're probably going to watch eventually, while doing this video, Sonia Sotomayor and Antonin Scalia. They are the ones that discuss a lot of the ideas concerning activism and restraint. I've talked about my favorite little person on the court, who is Ruth Bader Ginsburg, as, you know, the feisty, very opinionated 87-year-old lady. Well, there's more feisty ladies on there. One of them is Sonia Sotomayor, but also a recently deceased member, Antonin Scalia, was the opposite end of this idea of activism and restraint. He was on the restraint side, meaning he took the Constitution and read it as is. Basically, he said in the 1700s, this is what they wrote, this is what they meant, and this is what it means today. So there's no wiggle room. So we're going to kind of talk about, should there even be wiggle room within the Constitution as a Supreme Court justice is, you know, reading it to make decisions on cases. All right, so go into Google Classroom. I want to make sure y'all see what is up there. Every class has the same stuff. I've tried to keep it in the exact same order. Everything over here on the left-hand side, that's the stuff that is dealing directly with the judicial branch. Okay, so that is our current unit. Everything after it is stuff to help you guys study. Okay, so it's stuff dealing with the test, the exam. It's gonna happen, so you guys need to get yourselves prepared. Unit 1, Unit 2, we are finishing today, and then Unit 3 is the one we haven't touched. Now, I am actually going to wait until April 3rd, which is when College Board is coming out with exactly what they're expecting from us as far as on the exam. And that will determine how I go about that last unit, the 3rd unit. It is by far, to me, the most interesting unit. It's on civil rights and civil liberties. So it's going to be about African-American rights, women's rights, LGBTQ rights, handicap rights, all of these different groups of people that have been disenfranchised some way, shape, or form. And it's how they have used the court system, remember, the reactive court system, to get their rights, to look at the Constitution, look at the Bill of Rights and go, wait a second, nope, this particular, you know, amendment says you do have that right. So I find it by far the most interesting of all of the units, and it's actually why I leave it till the end, is because you guys will become interested in this, because a lot of it has to do with you. Last, let's see, the 3rd day, I believe, of the judicial branch, I talked about New Jersey versus TLO, which was about search and seizure of students on campus. And many of you guys probably thought, you can't search my stuff, but they can. Administration actually can. And that comes down to a Supreme Court case dealing with Piscataway County in New Jersey and a girl, a 14-year-old girl. So the judicial branch and civil rights and civil liberties are incredibly important for you as just a citizen of the United States, be it an underage citizen, but you're still a citizen with certain rights. Okay, I also have put up, and I posted it in a couple places, something called Padlet. Some of y'all don't want to ask me outright because your name is attached to things when you ask me stuff. So I made this, and it can be anonymous. However, it's now 4 days, and I finally got my first question. Okay, and as you guys can see, it says, what are your questions concerning the judicial branch so far? I put this up immediately after I posted the Federalist 78 analysis, and I sat there and I checked it, and then I checked it again, and then I checked it, and nobody was answering or asking questions. So it was very frustrating because you guys will ask questions in class, but then you weren't asking questions by way of me putting something out there for you to get cut and dry questions and answers back and forth. Finally, someone asked me something, and they were asking about Federalist 78, and I have a feeling based on what they asked, they did not look at the analysis that I put up, the video analysis. So before you ask a question, make sure you check all of your sources first, because I'm going to lead you to that source first before I outright answer a question. You know I do that in class. This is no different. You've got to work for what you want. So I'm keeping it up here. So if y'all have any questions, it's still up there, and you can get to it by way of, I posted on Remind and on Google Classroom. So let's talk about these College Board live study sessions. Right now, while I am talking, there is one of them going on, which is finishing up Unit 5. Now, the reason they are doing that, because everybody, all adults have been wondering, why are they going over stuff that they know is not on the test? For colleges to allow you to have credit for this course, they have to completely teach. College Board has to make sure that they have taught this with fidelity, which is why the Jennifer Hitchcock live videos right now on YouTube are all concerning things that we have technically already learned. It's stuff that we learned in November and December. So I think today she's going over interest groups, I believe. After she is done with Unit 5, then it's going to be nothing but daily review for this test. Okay. Now I've started putting up some things on my website, specifically the judicial branch. At the very bottom, I put a Supreme Court case video on how to actually do the comparison FRQ. So those of y'all that are not doing the FRQs that I have put on AP Classroom, I've graded some of them and given feedback to some people so they know what exactly is wrong with their answer. Y'all, that's how you prep yourself. You've got to do the practice. If you don't do the practice, you're not going to do well. Like, that goes with sports. That goes with, if you're a dancer, it also goes with, if there is a test on history, you're going to have to practice. If there is a skill that you have to do, you're going to have to practice. So I suggest everybody watch these. Jennifer Hitchcock is amazing. I've talked about her before. Love her to death. Each session is going to have an agenda if you haven't looked at them yet. There will be topic help, study help, FRQ help. She's doing a lot of stuff with FRQs, mainly because she knows this test is going to be FRQ based. Again, on April 3rd, we will find out more about that. So go there. The link right there is where you need to go. I've also posted it multiple times on Remind, and I know a few people are watching them with fidelity, and I appreciate you, because it will help you, and you guys will be the 3s, 4s, and 5s if you are doing what I'm asking you to do. Exam updates. This is so far what I know from College Board, okay? The AP exam will be 45 minutes. The AP exam will be online. The AP exam will be only FRQs. And the AP exam will only deal with Units 1, 2, and 3. Unit 1, that's going to be your foundations. That is August and September, okay? Unit 2, that has been for us since January, February, and March, and now a little bit into April. That is Unit 2, institutions. Unit 3 is civil rights and civil liberties. That's the one we haven't gotten to yet. And after April 3rd, I will know exactly how I need to attack that, because if I know certain things are going to be tested and certain things aren't going to be tested, you better believe I'm going to help you guys for this test. At this point, usually I like to give you the well-rounded, education that you deserve and get all of the good stuff, all the bits, all the pieces. But right now, this situation has turned it into, I want you guys to pass this test, and I'm going to help you in any way I can. You guys have to pull your weight, though. All right, and the last thing over here on the right, I've talked about Trevor Packer before. Trevor Packer on Twitter, it's AP_Trevor. He is the vice president of College Board. So anytime anything changes or is an update or something, he posts stuff. And I found this thread right here, and I thought it was very interesting. It says, from Mr. Louder, whoever Mr. Louder is, I haven't seen this specified anywhere yet. Will this be an open book, open notebook exam? And Trevor Packer, again, vice president of College Board, says yes, like a college exam. Just so you know, I've never had an open book college exam, but that would be great. These exams will be open book, open note. They won't test simple factual recall. So those easy questions, like, easy multiple choice, that's not going to happen. It's all FRQ based. Instead, they'll be focused on skills and thematic understandings, okay? So hopefully April 3rd, they're gonna give us some more information about that, and I can hit you guys up and let you know what's going on. Okay, so I kind of wanted to show you guys what this is going to be dealing with. So in your table of contents in your book, it's going to be from chapter 1 to chapter 9. All of the stuff from chapter 1 to chapter 9 are fair game, okay? So we have done everything through chapter 7, no, through chapter 6. After what I talk about today, we have gone through chapter 6. So that just leaves chapter 7, 8, and 9 for us to deal with before this test. And we don't have a date for the test yet. So when you look in your table of contents in your book, chapter 1 through chapter 9 is what our test will be on. Okay, so I'm going to go back and forth through screens for just a second. I wanted to kind of do a learning log because we haven't done those in forever and we haven't seen each other forever. So we're going to pretend like you guys have your learning log paperwork out for your Google Classroom learning logs. Do you believe the Constitution is a living document? Okay, so you got to kind of think about what that means, a living document. Or should there be what's called strict adherence to the specific wording of the Constitution? So should the document change with society, a living document, or should the words on the paper be the words on the paper and how they were meant when they were written? Okay, so I want y'all to kind of think about that. I am going to swap real quick and go to a different screen, and I will probably, let me see if I can make myself disappear. No, I don't want to make myself disappear. So I'm going to stop sharing and I'm going to go to a new share real quick, which is going to be a video on my website. If I can find my website, it's up here somewhere. Here we are. All right, so I'm going to Unit 3.4, Institutions, Judiciary. Scrolling down, scrolly scroll, 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 scrolly scroll, 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 scroll. That was last time I talked to you guys. Scrolly scroll, scroll. Okay, I'm going to show you this video right here. This is Sonia Sotomayor. She is one of the newer justices. Let's see, we have Neil Gorsuch and Brett Kavanaugh are the newest, and she will be the third newest on the court. So she is going to be a Barack Obama appointee. Of course, we have to watch it.
Typically, it's the last one.
Goodbye, Ad.
Given that, is the Constitution a living document, open to interpretation, or is it something that must be read strictly and adhered to regardless of the day?
You know, Scott, that is the question that is asked constantly of judges. There are some things in the Constitution that are black and white. You can't, except during times of war, the government can't quarter troops in people's homes. Now, even in that black and white situation, what is the meaning of quartering troops? If there is some sort of war effort going on in the United States and the government knocks on your door and says, our guys have to go in there for an hour and re-provision themselves or use your bathrooms or do something like that, the courts may be asked, is that quartering troops? Is that a constitutional violation? There's always that sort of twist in what happens. And then there are provisions that are very general in the Constitution. You can't have an unreasonable search and seizure. What does unreasonable mean? What's a search and seizure? On those three words, search, seizure, and unreasonable, law books are filled. Shelves and shelves of them are filled. And so to talk about strict interpretation or living constitution, those are not words I use. And they're not words that I think have much meaning, because what you are doing is interpreting new facts to an established law that in part has been given meaning and precedent, and that in part has a historical background. And you're drawing from all of that toolbox of precedents, history. Some of my colleagues don't rely on history, but others do. And from statutory construction principles. It is not about reading words strictly or about living constitution. It's about giving meaning on the basis of facts that are presented to you.
And now to a rare.
Okay, guys, so let me come back. It's me. I'm gonna go back to the PowerPoint. Let's see. Okay, so do you believe the Constitution is a living document, or should there be strict adherence to the specific wording? Now, Sonia Sotomayor, she kind of didn't say which is the best. She did say that you've got to deal with the here and now. You've got to deal with what is going on now, and how does that pertain to the document at this time, which makes me lean towards she looks at it as a living document more so than strict adherence to the words. There isn't a right or wrong answer to this, you guys. The justices that are currently on the bench, some of them are very much living document. Times change, those words have changed. Some of them are very much the opposite. The words are the words. They were written in the 1700s. This is what they mean then. This is what they mean now. We are not going back or forth on what we think the meaning is. So it's interesting. Their whole job is to interpret those words from the 1700s and any amendment that has come after that. So it's very interesting that they have to kind of argue that out within themselves, but also with each other. Is it living or is it strict? What do you think? So consider that when we talk about the rest of the stuff throughout this PowerPoint. Okay, so judges and policymaking. Now that's kind of an oxymoron, because a judge or a justice should not be making policy. Remember who makes our policy? That's going to be our legislative branch. They are the creators or the makers of law. However, through judgments by way of the court, sometimes there is new policy. An example would be something that happened in 2015, marriage equality. In 2015, we had Obergefell versus Hodges, and out of that comes policy. Out of their judgment on a case comes new policy for every state to adhere to, which is going to be that we can no longer discriminate. A state cannot have laws that say you cannot get married, you cannot get married, you cannot get married. They can't do that. If you're a citizen, you have the same equal rights for marriage as the next citizen. Okay, so do courts make law? Technically, no, but their judgments can create new policies and in turn kind of create new law. They make law by way of what is called common law. Common law is deciding and establishing legal principles that guide the future. So that idea of precedent or stare decisis is this idea of common law. What we've done before is what we should continue to do unless something changes. And then we may have to, reconfigure and look at the facts of things and of the time. Society changes, perhaps, the judges and justices opinions will change. So this lawmaking function ensures judges have a powerful role in public policy, but they are not necessarily true policy makers. Okay, so it's kind of one of those things. Remember, in the Constitution, they didn't really have instructions. So this is something that has come out of the practice. They do make decisions that affect all parties involved, and affect all parties afterwards as well, because what they determine becomes the precedent for the next generation until another court sees a case about that same thing and says, maybe you were wrong. We're going to talk about an example of exactly that, where the court in one century says something is now law, you got to do it this way, and then a little less than 100 years later, the court says, wait, no, this is not right. That court was incorrect. So remember, new people, new presidents, new times comes new things coming out of the courts. All right, so we've talked about Marbury versus Madison. That's 1803, judicial review is going to come out of it. And it's where the power of the court is going to be seen and finally realized, where their actions by the other branches of government determine whether or not other actions from other branches is constitutional or not. So I said I was going to talk about the idea of one court versus a later court, and the example is Plessy versus Ferguson and Brown versus the Board of Education. You need to know those. Okay, so with Plessy versus Ferguson in 1896, the first Supreme Court is going to decide that the 14th Amendment did not prohibit or keep segregation of people, keep it away of people based on race in public accommodation. So basically, this is where what is called separate but equal becomes completely and totally legal. Okay, so we learn separate but equal throughout school. My daughter has already learned it in 4th grade. You guys definitely learned it in 7th grade and again in 8th grade. I know I used to teach those subjects. But you didn't necessarily know where it came from. So quick, little history lesson. Homer Plessy is from Louisiana. He is 1/8 African-American, okay? Which means he is passable as white. And these are going to be times in the 1800s where being passable as white is a huge advantage, okay? So he is going to be part of a citizens committee of Creole people. Creole, again, that's going to be a mixed race person, and from New Orleans. And they are going to set up the situation where Plessy is going to get on a train in Mandeville, Louisiana, and he is going to sit in the whites only car. Now, today that seems kind of weird for us because we don't have that kind of situation to even really think about. However, him doing that is punishable by law. So he sets himself up on purpose. That's one thing a lot of people don't realize. Plessy versus Ferguson. Plessy puts himself in a situation on purpose to get caught. Now, it's going to have a backfire reaction because what's going to happen is this case is going to make its way to the Supreme Court. And the Supreme Court is going to basically say, no, Mr. Plessy, they can have separate cars on a train. That is completely legal. You can have that. So they say the 14th Amendment doesn't deal with this particular thing. And as long as everything is separate but equal, we're fine, we're golden. So that's going to be the United States split of our two races at that point. So we had a lot of gaining of good stuff right after the Civil War because we have the 13th, the 14th, the 15th Amendment. But then we're going to go into what is called Jim Crow. Jim Crow are going to be de facto or de jure laws. So some of these are going to be on the book laws. Some of these are going to be not on the book laws. So for instance, train cars, that was going to be on the books. There were whites only train cars and there were blacks only train cars. Now Plessy, again, he's a little of both. So that was kind of his argument is like, how are you going to decide this? And they decided that if you have any form of African-American in you, so in this case, he was 1/8, it's called an octoroon, you're still black, get on the other car. And so this is going to be, it's going to create segregation. Plessy versus Ferguson is the reason segregation becomes law, okay? That's going to be de jure segregation. Now there's also going to be what's called de facto segregation that's going to exist in places where it's not necessary, but that's going to be racism fueled, basically. Okay, so let's go forward almost 100 years. We're going to go in the 1950s. Brown versus Board of Education is going to come up. You have a little girl named Linda Brown. A lot of you guys know the story concerning Ruby Bridges. This is not all that different. But Linda Brown, her house is close to an all-whites elementary school, but she is not allowed to go to that school because Plessy versus Ferguson is going to create separate but equal. But what's going to happen is, to get to her school, she has to cross a train yard. She has to do all of these, jump through all of these hoops just to go to school. And her father specifically is going to be very angry by this, because he's going to say, this is, yes, it is separate, but it is not equal. And we're going to learn that over the years, the education system in general is not going to be legal. It's not going to be equal. It's going to be definitely separate, but not equal. So with Brown versus Board of Education, the court used the same common law principle. So they go back of judicial review, but this time, remember, we have almost 100 years has passed. We have different presidents. Different presidents have put in different justices, and now we have a completely different Supreme Court in the 1950s than we did in the 1890s. So they're going to use judicial review, and they're going to look at this. They're going to look back at the Plessy versus Ferguson case and what came out of that. And what came out of Plessy versus Ferguson is separate but equal facilities for all. It's going to be our water fountains, our restrooms, restaurants. There's going to be separate areas, train cars, bus seats, areas that would allow Blacks to rent houses. There was only certain parts of cities that would allow that and stuff. So it's kind of ridiculous. So again, court looks back. They are going to do judicial review, and they're going to look and they're going to say, well, wait a second. The 14th Amendment, let's look at that again. Under its Equal Protection Clause, okay, the 14th Amendment is going to basically say that we have equal protection under the law, meaning every citizen, if you're an American citizen, you got the same rights as the next guy. Race does not come into play. They find that segregation due to race is completely unconstitutional. So if you look at that, that's the Supreme Court in two different instances looking at the exact same issue, and one court says yes, and then almost 100 years later another court says, oh, that's not allowed. So different people, different times, society changes. Going back to that idea, living document or strict adherence to the document. The Brown case is said to be a catalyst. A catalyst is something that like sparks something happening. A catalyst to hundreds of cases that are going to be concerning violations of rights concerning race specifically, but also gender, which we will talk about in the next unit concerning civil rights and civil liberties. Okay, so let's talk about this idea, judicial activism and judicial restraint. Activism, think of an activist. What are activists to you? I like to use PETA a lot in class. PETA are the people that are people for the ethical treatment of animals. They are activists for animal rights. Now, they're an extreme version of an activist. Feminists are activists, and there are levels of feminists. Now, judicial restraint is the idea of reading the document as is, period. Okay, so it's a very weird place to be if you're either one or the other. So judicial activism refers to the court's willingness to strike down laws made by elected officials, so to strike down those things that the legislative branch has created, as well as to step away from past precedents. Remember, stare decisis, precedents, stuff that's happened in the past. Judicial activism is willing to say, that was wrong. We should not have done that 100 years ago. It should have been different. And they can use that power of judicial review to change the course of history, really. Judges view the document or the Constitution as living, meaning it flows with society. Society changes. Perhaps the interpretation of those words also changes. So 2 specific courts I want y'all to look at. The Warren Court. Earl Warren, that's this guy right here. Anybody that went to Washington, D.C. and went to the Supreme Court with me, I looked for all the Earl Warren things because his court as the Chief Justice is very interesting. It's usually referred to as one of the biggest activist courts that has existed because all kinds of things came out of this particular court that bettered society, in my opinion. Maybe not everybody's opinion. So I suggest you guys read about that in your chapter. And then we have something that's more recent in the 90s. We have what's called the Rehnquist Court. Down here at the bottom picture, the man that has the stripes on his arm looks like, you know, almost like sergeant stripes. He is the Chief Justice. His name is William Rehnquist. He has since passed away, which is how John Roberts ended up becoming the new Chief Justice. But yeah, William Rehnquist and his court were labeled the most activist Supreme Court in history. So again, those two courts, I suggest you kind of peek at them in your book. They're very interesting. The Rehnquist Court attempted to restore states' rights. So if we go back to Federalists and Anti-Federalists, I told you guys all year we're going to talk about those two sides. Federalists and Anti-Federalists, the Anti-Federalists were those states' rights groups. They're the ones that wanted to fight for having more rights. They liked how the Articles of Confederation gave the states autonomy over themselves. So they weren't necessarily civil rights activists. In this case, they were states' rights activists. The court limited the rights of citizens to sue their own states in federal court. The court was relatively cautious on civil rights. So they didn't have a lot of like, oh my gosh, moments concerning civil rights, but they did concerning the federal government coming into play and the state governments having more autonomy. Ruling that some things that we're going to talk about later, affirmative action is acceptable, but within strict limits. Now, if y'all don't know what affirmative action is, which has been in your readings before, but I have learned over time, especially this year, that you guys barely ever opened your books. Affirmative action is this idea that to make sure underrepresented groups get looked at and you know, put in play if they were normally overlooked. So to give you an example, the NFL or even NCAA, anytime a coach leaves and there is an opening for a coach, every team that happens to, they have to have at least one African-American applicant to interview. That's affirmative action, to make sure there is the minority that is allowed to be given that chance. So this particular court was kind of about affirmative action, allowing businesses to kind of scoot around that a little bit. They did have a striking ruling concerning civil rights and gay men, however, in 2003. It's called Lawrence versus Texas. This is actually going to be in your Civil Rights and Civil Liberties unit, but it is something that happened during this particular, the Rehnquist Court. Every state has laws concerning homosexual sexual actions or intercourse. Many states, I believe it's 37 at one point of our 50 states, had what's called anti-sodomy laws, which is specifically against gay men and sexual intercourse. Well, in 2003, you have Lawrence versus Texas that's going to happen. And what it actually is about is interesting, because it's about having a warrant to go and search. But once they went and had the warrant to search, the police officers walked in on two gay men. And in Texas, they had anti-sodomy laws, which said that was not legal. Therefore, they arrested these two men concerning the sodomy law, even though they were there for something completely different. Well, this is going to make its way through state court, state Supreme Court, all the way up to our federal Supreme Court. And it basically says that you can't do that. That's a privacy issue. So it's very interesting that becomes, seems like something that you don't really think about as being, an issue, but 37 of our 50 states have had laws that said that was illegal. And this says you can't go in with one intent as a police officer and end up arresting somebody for this other thing. So it is a civil rights case, in that is dealing with civil rights of specifically gay men. Okay, so judicial activism and restraint. Let's talk about that restraint end. Judicial restraint is limiting your power as a justice by the words of the Constitution. Okay, meaning you're boxing yourself in, which means you're losing power because you are using everything in the Constitution as your guide. Whatever it says, it's the law. it's done stamp, you're not interpreting words. So it's limiting the power of a judge by deferring to the democratically elected legislative and executive branches. So it's basically saying they have created a law. That law is then set in stone and added to the Constitution, okay? People that practice this believe that the judicial system, or the judiciary, is the least democratic branch of the government. And it really is. You're appointed, you're confirmed, you can be anybody, honestly. Should not check the other branches unless their actions clearly, without a doubt, violate the Constitution. So no wiggling around the words, no thinking about what, you know, Hamilton may have been trying to say or anything like that. The words of the Constitution are the words of the Constitution. Done, stamp, period. Boxed yourself in. Okay. Now, one of the men that is on the Supreme Court is this man right here. His name is Antonin Scalia. He died in 2016, I believe, February of 2016. He was known as a strict constructionist, meaning he felt that the words of the he used judicial restraint. Everything that he ever wrote as far as his opinions of the court, they were always about, this is what the Constitution says, period, done, stamp. Okay. I think it would be very, very hard to be somebody who uses judicial restraint, mainly because my emotions get in my way when I'm thinking about things. So this is basically setting aside your feelings, setting aside society's change, and looking at what does the document say. A lot of people disagree with judicial restraint. At the same time, it's also, you know, a good thing because it keeps you boxed in. It keeps you from saying, oh, but I feel this and blah, blah. It keeps you, justice is blind, and it keeps you that way. All right, so some of the things concerning my computer's falling. Activism and restraint. So y'all can have some better ideas of what exactly I'm talking about. Judicial activism. We talked about Plessy versus Ferguson and Brown versus Board of Education. I'm going to use those because they're easy and you need to know those two cases. It can be argued the court did not interpret the Constitution, but instead amended the Constitution. The Supreme Court of the United States assumed what's called quasi-legislative authority, which is basically like fake authority that you really don't have, but you kind of used, and drags the other two branches along. Whereas judicial restraint, the court follows precedent, things that have happened before, and shows restraint by using the document, boxing yourself in. Precedent is allowed to be challenged within judicial restraint, but it has to be something that is blatantly realized that the former court did not do their job properly. Precedent is the norm, and the court does move slowly, if at all, because of precedent. It is very hard to change something that has happened if it's already happened through the court system. So the court has little power to enforce its decisions. That's kind of the big problem. The court comes up with these ideas, and now once it's been written, the opinions have been written by the Supreme Court, it then has to be followed by the states, and that's usually where things get screwed up. The states don't like to follow directions. They like to do their own thing because they're like, states' rights, I've got autonomy. But when we go back to the Constitution, Article 6, the Supremacy Clause, says whatever comes out of the Constitution is law. Well, guess what? When these guys, these 9 justices, make a decision, that is the law of the land. So anything they do gets basically added to the Constitution. So it's kind of interesting that, again, they are reactive, and then the states themselves, whether they like it or not, are supposed to follow this reactive branch, and a lot of times they don't. That could be, you know, we can use civil rights after segregation was shot down and you had to integrate schools. That was in 1954 when we had to integrate schools. An example, Lafayette Parish did not integrate their schools until the 1970s. So that shows you law was created in the 1950s, but states and localities did not necessarily do what they were supposed to do until almost 20 years later. So it kind of shows you a downfall of what happens with the court, because sometimes the court says something, it's supposed to be done, but states do not necessarily adhere to the new law. So how do these justices deal with the Constitution or view the Constitution? So strict construction, that's going to be your restraint. Okay, that means it's a philosophy that looks to what's called the letter of the law. So they don't necessarily try and wiggle around the words to fit things. So when interpreting the Constitution, they look at what it says and is what's going on with this case. Do those two go together? Do we change what's happening based on what the Constitution says? It's a hard place to be because, again, strict constructionism, like Antonin Scalia, is boxing yourself into a document and not looking at the change of time, societal changes, cultural changes, your heart, any of those things. So it's a difficult, to me, it would be very difficult to do that. Broad construction or loose construction is going to be this idea of the activism. Philosophy that looks at the context and the purpose of the law when making the interpretation. So what did they mean in 1792? And what does it mean today? Does it have that same meaning, or do we need to look at it a little differently? Okay. I have a little link at the bottom. It goes directly to another video, which is on my website. I'm not going to show you guys that. It's basically Scalia and Justice Breyer, Stephen Breyer, talking about what they feel their job is as reviewers of the Constitution or interpreters of the Constitution. And they're going to talk about the idea of being very strict versus very broad in the of looking at the Constitution. Okay, so I do not know how they're going to work these FRQs on our test. All I know is it's going to be FRQs. So it's possible that they could use some kind of stimulus, like a picture. So I brought this one out because it's directly related to what we were talking about today. And if you notice, it's a big dam. It looks like the Hoover Dam. And then if y'all know what a dam does, it's holding back water. And in this case, you have judicial activism is being held back by this big dam. And notice the dam has Mr. Scalia's name. If y'all remember, what did I say happened to Mr. Scalia in 2016? He passed away, which means that wall, that force that was keeping the court from becoming too activist or too much of a loose interpretation of the words of the Constitution was gone. So once that dam broke, the court became very much an activist court because he was not there to kind of be the barrier and be no, the Constitution says this. So good or bad doesn't matter, but it just shows what that means. So when y'all think about these, the possibility of the FRQs having pictures could definitely be something like a cartoon. It doesn't have to be a graph or a chart. It can easily be something like this. And this is a perfect example of what would happen if your court leans one way, you lose one of them, and it starts tilting the other way into an activist court. You lose your strict guy, and then you start leaning more the other way towards an activist court. Okay, so what checks our courts? Remember, we have checks and balances. Montesquieu, he said we have checks and balances. We have branches of government. The executive checks, the president has the power to enforce judicial decisions through the use of the bureaucracy. Remember, the bureaucracy is that other kind of appendage of the executive branch. It's not just vice president, president. It's all those different agencies that actually enforce the law and regulate things. In rare cases, a president may refuse to implement a decision, but it is incredibly rare. More frequently, presidents use their power to appoint and check the judiciary. So remember, the president, if there is an open spot, that's one of those big pieces that the executive branch has. They get to choose somebody to be on the court. And if you choose a guy that doesn't have anything awful about him that the Congress can figure out, they get put on the court, and that's going to be that president's legacy. But yeah, so technically the executive can put a halt on some of the things that comes out of the judicial branch. Legislative checks. Constitutional amendments are going to be an easy legislative check, and revision of laws. So say they throw out a law, they find a law completely unconstitutional within the court system. Well, the legislative branch can kind of wiggle around that and revise how laws are written and dealt with. And then public opinion and public accountability, you guys, we check them too. Ignoring the court, the states, the localities ignoring the court, which is called de facto, meaning we just don't do what they say. We choose that. Also, civil disobedience, the idea of protesting, doing things anyway and going, what are you going to do? So we have a check on that as well. Now, traditions and doctrines of the judicial branch. Sometimes, if you really think about it, the courts also will check themselves. Hypothetical and political questions. The tradition of refusing to adjudicate hypothetical questions. Adjudicate just means going to the court. They don't look at or deal with or interpret what ifs. No hypothetical anythings. So that's kind of something that they are like, that's the other branches can deal with that, because they don't deal with what ifs. They deal with solid, clear, concise, concrete things. The impact of the lower courts. If a lower court dislikes a Supreme Court ruling, they cannot overturn anything. They can, however, play around with how things are implemented. So sometimes the lower courts can be kind of sneaky with that. Because again, what comes out of the Supreme Court is the law of the land, is added to, is supreme as far as what we have to follow. But it all depends on how the lower ends, the states and the lower courts within those states, how they determine, do we even want to do this? Now, eventually, the reactive branch can come back on that, but you got to have somebody saying, wait, the state's not doing that. All right, so I do want to talk about Antonin Scalia a little bit. I've talked a lot about Ruth Ginsburg. She's still alive, so she is still the feisty lady that's on there. Antonin Scalia, however, he did die in February of 2016. He's usually referred to as the originalist because he was so set in his ways about looking at the document as is. He was chosen by President Reagan as a nominee in 1986. So he was on the court for a very long time. He was unanimously confirmed 98-0. He took his seat as an associate justice on September 26, 1986. Justice Scalia was never at a loss for words. He would fight. He would fuss. He would have 2 cents to put in every argument. He asked many, many questions. So when you have, I don't know if y'all remember, but we talked about the process of being in a Supreme Court case. You have 30 minutes. And in those 30 minutes, the justices can ask you questions if you're an attorney. And he always had questions. He was probably one of the more vocal ones, along with Ruth Bader Ginsburg. He was brutal. He was very, brutally honest with people when he would ask those questions. He was what's called meticulous, meaning he would find little bitty pieces and minutia to ask about. He also possessed a very funny sense of humor. He regularly would crack jokes in the middle of Supreme Court cases, which made him very likable, but also dislikable because he also was doing that strict adherence to whatever is in the Constitution. He wrote more concurring opinions than any other justice in Supreme Court history. Remember, the opinions, you have the majority opinion, you have the dissent. So the concurring opinion is agreeing with the majority. So he wrote more than any other Supreme Court justice in history. And he's also the 3rd highest dissenter. So one of the highest dissenters right now is Ruth Bader Ginsburg, the cute little lady. And he was also one of the most dissenting justices within the court. So he was the most, he wrote the most concurring opinions with the majority, but he was the 3rd most for the dissent. So it's kind of interesting. He was very good at writing his opinions, but he came across as offensive at times. That's that brutal honesty, kind of like me. He was an originalist. So he felt that the interpretation of the Constitution means you had to look at what was the intention of whatever they wrote when they wrote it. That has to come into play every time you're making a decision. So he is the ideological opposite of living Constitution. So he is the words of the Constitution. How did the writers mean it? And that's how we have to deal with it. So it's kind of interesting that he was like that. I find him and Ruth Bader Ginsburg, two of the more interesting. That's the only reason I've used those. Those are just completely my opinion, that they were interesting characters within the judicial branch. Down here at the very bottom, that is his seat with the black drape on it. If you notice, there's 3 seats, then the one with the black drape, and then 1, 2, 3, 4, 5 seats. He was right next to this middle seat right here, which is where the Chief Justice sits. The most senior members, meaning the people that have been there the longest, are the ones that sit closest to the Chief Justice. So he was one of the oldest members, not oldest in age, but oldest as in serving on the court. So he was right next to, at that particular time, would be John Roberts. So anyway, you guys, that is the end. That's the end of the judicial branch. Remember, judicial restraint means that you are holding back your opinion, holding back your heart, holding back what society says. You are looking at what the Constitution says, what was the intent of the people that wrote the Constitution, and that is what you're looking at. Whereas activism is the idea of using your heart, using feelings, using the change in society, using the change of culture to help you make your Supreme Court decisions. Neither one is right, neither one is wrong. Most justices are probably a little smushed up of both. But yeah, so that's the end. I wanted to make sure you knew how those decisions were made. Take a peek at those different videos that are up there. There's one where it is Antonin Scalia and Stephen Breyer talking about activism and restraint. And then there's 2 on the outsides on my website that are dealing with, one is Crash Course and one is about the decision making of the court. All right, you guys, I will probably send you guys in the next couple of days a join code for one of these new things called Microsoft Teams. It will be very similar to Zoom. However, it'll only be 4 people showing up. It'll be like 4 little boxes and maybe a chat screen on one side. It will be an experiment. We will not do, I mean, we can have questions and answers and so y'all can ask me stuff, but it will just be an experiment to see how it works, kind of get bugs out that we come across. And then after the 3rd, April 3rd is when College Board is going to come out with everything that they want us to know about this exam, besides what they've already told us. So they're going to give teachers more directions on what we're going to be doing. That will help me with this last unit, how I need to teach it to you guys. And whether or not we need to continue what I've been doing, which are these recordings, or if I need to go into more live back and forths, which I would like to do more lives with you guys so we can talk about structure of FRQs and things like that, which I will be posting some more FRQ helper videos from Ms. Hitchcock. She has one for each one of the FRQs. Once I know, if they let us know what kind of FRQs, you guys, I can help you guys so much. And I'm kind of excited that they're going to let us do that. And remember, according to Trevor Packer, he does say it's an open notes and open book test. So anything you have can be used to help you, but you only have 45 minutes. So I'm thinking we can actually work this out pretty cool and make it work out and make you guys do really well. I am still going to be doing the grading. However, the grading for the AP test is a little bit different this year. We get to stay at home. So boo on that. I don't get to go to Utah. And see beautiful mountains and hang out with cool teachers and things like that. But everything will be me grading it just like I grade stuff on AP Classroom. So me and a computer. Not exactly what I was hoping for, but I will still get the experience. And we will get to talk about it after the test. Can't talk about it until after the test, which don't have a date yet. That's another April 3rd thing. I hope that's going to come out. Keep in touch with me via either the Padlet, Google Classroom, Remind. Also, make sure you are keeping track of College Board YouTube every day, 2 o'clock. Jennifer Hitchcock, Monday through Friday, is going to be talking to you guys and giving y'all hints and helpers and stuff like that. So see you guys later.